Okay, well, good morning, everyone. And we're here on Wednesday morning with Henry, who's going to be talking to us about COVID-19 and your construction contract. It's an update to his seminars during the first weeks of lockdown, when we were looking at contracts and how they may be affected by social distancing, safe working practices, etc., etc. So Henry's going to be giving us an update to those initial thoughts today. As always, Q&A panel if you've got any questions, and Henry will happily answer those at the end. And thank you very much for turning up. Henry, the floor is yours.
Good morning, everybody, and thanks very much for joining. And welcome again. What is a rainy day, actually, in Ireland, where I currently am. The purpose, really, of this session is really just to reflect on what's actually happened and what we actually see foreseeable within the next number of months. And this is like now, as one commentator had said, we're now currently in a position of the end of the beginning. That's really where we stand. We've managed to, we're gradually now seeing society and industry going back in a phased release, and as has been often suggested by quite an awful lot of governments, it's a hell of a lot harder to kickstart an economy than it is to close one down. Construction, of course, has always suffered quite a lot. It is predominantly one of the most litigious, dispute-centered industry and activities that is currently to the forefront. None of this is going to change. In fact, it's probably going to become more exemplified. We now have, if we, as I said before, if we thought Brexit, and having had a 2-hour conversation with a very good client over a number of years yesterday evening, talking about everything in terms of how business is affected, the foreseeability, and of course that other experience of having gone through previous recessions. What do we expect? Having talked to analysts in terms of economists, accountants, what do we see in the future? And one of the principal areas, I did a lecture, a seminar recently in respect of insolvency, and right up until the end of March, there was 3,077 insolvencies or liquidation of construction companies in the UK. And that was to the end. The significance of that figure is it only goes to the 31st of March. We're into a new quarter now, and we are now into the COVID-19 era. And it's stark, and it's a predominantly worrying figure, where parties had mentioned previously that Brexit was the forefront of concerns going into the new financial year. If Brexit was simply the kindling, well, COVID has been the petrol on the fire. Overall, many parties are suggesting that while continuing contracts are completed, they expect it to become quite difficult in the future. So realistically, I would like to split this into 2 different areas. First of all, in a contractual nature, and then on the pragmatic, I suppose. So they're talking about how the operation of COVID-19, all those terms like force majeure, etc., what are the likely effects on contracts, performance, any particular information to provide, and then, of course, to talk about what do we think will actually happen within the industry, given all of the different commentaries we've heard to date. We are now essentially moving back into work, and everything, of course, has been quite different. We've seen quite a numerous amounts of arguments in going back to workplace where social distancing becomes part and parcel of nature, whether or not it's foreseeable, but certainly the contracts have actually, the performance have changed. Up until recently, the key question talks about frustration, force majeure, and we talked about those quite often. Those questions, while important at point, we now need to consider what is the actual effects that will of continuing through this type of disruption. So where parties had intended, for example, a certain resource over a certain time to complete a certain activity under a construction contract, that is likely to be impacted. Often beforehand, we had decided and suggested that whether or not force majeure would be an actionable point would be naturally whether or not it was an express contract position. It's not a common law. It's not implied in the contract. It's actually a French term. We've mentioned that numerous different times. Is unlisted or unlisted. We're back really to the status of what or where is it defined in the contract as a matter of right. Whether or not the employer can be bound to actually suggest or bound to take risk for these events really are coming to the forefront. But from all feedback we've been given to date, parties appear to really be seeking to resolve this at the end. We've seen that consistently throughout. We're not quite sure that the hard questions are being asked quite at this stage, perhaps because of the uncertainty, but perhaps because they think that there will be an area of rights or outside of their control that can be resolved at final account. The fear really is that numerous parties will enter into final account disputes based on the amount of time allotted and, of course, on the actual quantum of the sums that they feel that they have lost. There's pragmatic reasons for that, and it reflects the trends and habits that we've always seen within construction. These are reasons why, the very reasons why we've always seen disputes and why we're trying to avoid disputes and how we think we can avoid them by looking at the trends and patterns and looking at all of the disputes that we've been involved with over the course of the last, say, 4 years, and looking at how they actually crystallize, when they manifest themselves, and how the tendering period actually comes into place, and of course, how to actually avoid and how to negotiate without actually entering into disputes. Those simple changes, those simple principles will become more and more important now. I can't think of anything more contentious than leaving it all, not stating the positions now at this stage in time, and leaving until the final account. When the whole pandemic commenced, much of the work that I was doing at the time were actually in deeds of variations to existing construction contracts to actually seek agreement to provide that certainty as to time, certainty as to money, and in relation to that, those opportunities still exist. But if we're not analysing what type of changes there will occur, so it's allocation of risk, and ultimately they can be agreed, and those changes can be. It provides a certainty to parties if they can reach agreement on that. What it does is it avoids the distraction or the certain contentious point whether or not it was ever force majeure. Certainly we've discounted whether or not it could be. But those questions are very, very live at this stage. So to run through to a final account position and then plead force majeure at that stage is far too uncertain. The judicial authority is not there at this moment in time, although we think that it will be in the future. But this is about certainty. It's about certainty of going into an economic downturn and certainty of funds for any different organizations. And when we talk about the insolvency further, about what to do in relation to cash flow, that will become very evident. But one of the questions that's already been asked as a pre-question was, how has COVID-19 changed the workings, or how has it changed the workings of a JCT contract? And the simple answer to that is it simply hasn't. The contracts are by nature, they are formed at that crystalline point. What it does is, if we look at contracts in the most simplistic format, it's agreement for an expectation reliance for a future outcome. Essentially now, if a dispute arises and we have this whole uncertainty, the goal at this point is to start creating elements of certainty. large problem broken down into individual component parts, resolved those individual component parts and built back up into the solution. So it's about agreements in different instances and how they are recorded to actually create that certainty, either in the contract, whatnot. If a dispute actually does occur at final account, and we expect quite a lot of them, considering the losses and expenses that will be incurred, one will always be brought back to the time of formation of the contract and what the common intention of the parties were. Chief amongst that question will be, if there was a pandemic that occurred, what did the parties intend at the time of contract if such an event were to occur? Was it foreseeable or unforeseeable? And that question becomes really, really important. But we've now moved out of the lockdown stage. We're now moving into the re-establishment stage. And one point that is really resounding on the back of this is how parties are actually preparing over the next number of months to discharge contracts. They haven't adapted from the current, even if they were to rely upon a force majeure. How does that actually, because the force majeure event, parties are certainly now not prevented from carrying out, if that's the case for the contracts, but there is disruption. And two separate questions, if you like. Because we now need to look at the question of causation. One of the simple things that having numerous discussions and any current instructions that we're getting in relation to delays and advice on the information that we're providing, one of the key elements is causation. And causation is, most parties will understand that if there is an outcome or event, the cause between either the breach and the losses suffered has to be continuous. There can't be any break in causation. And they are factual points of causation of how the breach, which you must establish, arrived at the losses. And 2 points really are becoming very concerning at this moment in time. First point really is the legal basis of causation and how parties are actually identifying that. Too many parties at this moment in time, we feel, are assuming that because the pandemic has happened, because it's once in a lifetime event, that surely on a justice or fairness aspect, it will be dealt with such. It will become a matter of contract as to the interpretation of actually how the resolution will come about. Secondly, if we move from legal causation, then is the necessary evidence of the disruption. And we are talking about disruption here. We're talking about a change of how parties are expected to work. Now, ordinarily, one might suggest that if there's a change to the EORs, or if there's a change to sequencing or quality or quantity, we're now looking to see, well, can we actually mobilize or bite in on the variation under Section 5, 5.1.1, 5.1.2? We're looking, is this a variation, perhaps? And if not, is it a loss and expense? So we have to really analyze losses that have been suffered. And of course, this comes back to what strategy will be. But if we can't, then certainly we need to look at what level of evidence is actually necessary. The question will always be prove that no loss would have been suffered at all, or prove that a point of that you would have, for the events, would have achieved. So the baselines and the markers at the time of contract will become incredibly important. We're looking at baseline programs, resources. Contractors generally and traditionally have never been, two reasons I expect, that they've never been akin to providing their level of resource that they intend to discharge a contract. First, namely, because simply it takes quite a bit of effort, and secondly, because it's divulging quite a lot of commercial and sensitive information. But if you're going to prove disruption, and we're back to the case of Walter Lilly versus Mackay in 2012, which dealt quite literally with the treatment of disruption as well. It dealt with it very, very well in what is quite a long judgment. we can foresee different elements of global claims coming forward as well, or total cost claims. And the prevalence of that is to, in fact, as much as possible, avoid that, to bring the level of evidence together. So on the point of establishing legal points of causation, an event or a breach does give rise, the nature of the change between, because remember, we have not completely stopped performance of the contract. We're now into an area of disruption. Disruption is key to one of the most difficult areas of construction law to prove both on a legal and a factual or evidence point. Evidence is absolutely key in this instance. How our program, the alignment, and we've often talked about the alignment between both the QS, the bill of quantities, and of course now the programming. So if we're now entering back in to this environment, we're now talking about reprogramming, potentially, or resourcing. If we're now talking about social distancing of 2 meters, how possibly, and this takes quite a degree of imagination in some respects, to use the best skills possible to determine and to actually envisage what will the outcome be, or how has this naturally changed. All different effects of, like, how concrete is poured, internal trades, identification of the different trades as well. If we have a highly predominant one, which is earth moving, which is all machinery, simply put, social distancing really does not come to that extent as much. If we're talking about internal trades, or where there are teams or mates working together, then we might be looking at that as first fix, second fix, etc. So where they're dependent. And we're actually breaking down the work elements, because now at this stage in time, it's not too late to actually be talking to employers or employing parties to say, how is this going to affect? So most construction sites will have discussed, they will have gone through the full extent of what the health and safety, and arguments have been raised, and I've seen certain articles in relation to, does the COSH regulations come into play for something of this order? The employer's responsibilities and duties of care. How, if somebody were to actually catch COVID while in a work environment, and if there wasn't strict adherence, how would that affect insurance? How would it affect the work or duty of care of an employer? And ultimately, how can you prove that that's where the actual person contracted it? So all these questions are fairly live, and there's no straight answers to those points. Rather than that, just to put the elements in to certainly protect and create that basis of evidence. So we think that the biggest problems will be the proof, the level of proof of measuring the differences between what was expected and what was intended at the time of contract, and of course at the end as well. Moving towards as well that there will be many more, unfortunately, conversations and releases. Certainly in the last number of days has not been particularly wonderful. Closures of certain supply outlets as well. The foreseeability as well, does that change labor, or does that change material pricing in the future as well, especially long positions on contracts? It's the rules in terms of insolvency have not particularly changed. There might be some deferments under the Act for wrongful trading and some relinquishing on those points. But ultimately, a company is insolvent under Section 123 if, in fact, they are unable to pay their debts as they fall due. Cash flow is going to become an extreme issue. It already has. Numerous different points, just a lot of different parties in any consultations that we've had and any conversations with accountancy companies and economists are really saying that their work is outdated. Like, no, their work is predominantly now on working at cash flow forecasts. There is absolutely nothing wrong. In fact, it's to be completely supported, where a party will actually look at each of their individual given projects and do a health check in terms of where they stand financially, the outcome of what the effect will be in terms of program, resource, or actually how to provide in the activity stage of it. If there are agreements to be reached, one must think, do we now vary the terms, if possible, of the original contract to seek agreement now to make it more certain for final account. The environment now at this moment in time in terms of disputes, we expect them to get more and more difficult, especially as the quantums increase. So therefore, what we're suggesting is to move in quite a lot closer. VAT deferments, deferring VAT, it's not a write-off, it's a defer payment. So as we see the prospect of the works actually squeezing, how margins are actually going to be thought of and looked at, and it's not particularly, especially for main contracting, it's not particularly overly attractive margin rate that there is in a lot of projects anyway. With the same rules, and we've often analysed different works of, say, of what's happened with Crillion, with Amy, with Interserve, these type of companies, and what the signs were and what the sort of markers were of these points. So when contracting with different companies, we're now looking to say, are we now looking at those with very, very low margin, with long payment terms, with difficult, complex projects? Are they carrying quite those liabilities? And is there any particular contracts that's not going quite well? It is a recipe for low margin, long payment terms, especially where there's disputed sums over amounts due. And they were simply all of the markers that were present prior within those companies as well. So the difficulty that if companies are seeing, and it's not as visible at the moment, if that payments have been deferred, then there is a foreseeability to suggest that next year, if the next number of months, next year, if companies have not got to the stage where they have made contingent points, contracting, especially with any parties, it is one of the cases that one might look for warranties. Warranties are, if you like, and I don't mean collateral warranties, I mean looking for warranties as in or even indemnity of a position whereby, by continuing through, that they are not insolvent, that they VAT returns, all of these things are in place, that they're financially sound. We certainly have seen from other law firms, and we have certainly put it out, asking for the status and for those warranties at this stage because it's not as visible. Remember as well that a company accounts deferred of filing of those as well, creates even less. So the accuracy of what we can actually see who we are, and remember as well that there's external influence as well on many different projects that we talked recently about, that while payment structures might be quite well or going quite well on one particular project, the other instance can be quite simple to suggest that what if there is a number of different projects that are not going quite as well? Will they have spread like a contagion in terms of the liquidity and cash flow of a particular project? And we mentioned as well materials. If we are to expect, for whatever reason, and we're not suggesting that it will happen, but it must be of a case that a party might actually perceive, will material prices be affected in the future between either availability, reduced resource? Will that affect it? The question just needs to be asked, and if so, if prices on contracts have been put forward in a contract now at the moment, aren't those prices of materials likely to change? How is that likely to be affected? So the questions of suppliers need to be asked now. What the foreseeability? Is there any agreements to be made with those long-term suppliers to suggest that 6 months or 8 months from now that there will be no price increases if there are those agreements able to be put in place now at this moment in time? Predominantly labor heavy industries or elements, or material heavy where the prices run forward. We are starting to see more prevalence, of course, in retention of title clauses being brought to the forefront, clearly on the basis of how the gap will occur. An employer having paid out on amounts that are either listed or unlisted, on-site, off-site materials as well, and therefore where the title is actually held by the supplier, who will usually look to hold title until full amount, but they'll pass the risk. So when we're looking at retention title clauses, split into two. The one party, it's risk and title. If you don't hold the title, but you hold a risk, and ultimately then that can be the case. So usually this wasn't as much because of the emphasis. We see that the emphasis is providing quite a lot more as well. Ultimately as well, the prevalence, of course, of bonds coming back to the forefront, standard word bonding, ABI, insertions of insolvency clauses now as well. So typically the market is starting to react that there are issues. So each different party having that opportunity to actually suggest to themselves, who are we contracting with, and what type of level of safety do we now encourage or do we see at the moment? Do we recognize any unscrupulous activity at the moment? Payments, as much quick return on cash as well, or payments. The uses of Section 112 as well, which is the right, a statutory right of suspension, even if it's not an express contractual right in that respect as well. So typically forming, this is actually a new beginning. And what we're actually looking towards and what we're looking to face towards is very different from where it was a number of weeks ago. A number of weeks ago, it was quite simply facing down on the basis that most sites, not all, but quite a number, were actually closed. That was a straight question then, and not always quite clear the straight answers to be given, but certainly the question was, there was no activity. Quite easy to measure. Going now into this environment, where the difficulty stands that this is now a moving target. It will be most unlikely that the intention, common intention at the time of contract, in terms of how the performance was to be put forward, how that will be affected. The level and measure of disruption is going to be key. The understanding of how to measure that disruption. Of course, as well, it's now, now all of the basic principles have all raised their heads. Concurrency. How do subcontractors interact? So if one subcontractor on a particular given project has been affected by the current guidelines or the site constraints, that affects another subcontractor. How does that then transfer that the secondary subcontractor may suggest that they've been that there's an impediment, prevention, or default, albeit that the primary reason has been for the changes and constraints, but causally it has been another subcontractor that has affected them from entering into that area. So all interesting points now happen of who is actually the one that bears the risk. So the detailed points on that, we often have seen clauses in subcontracts, which is to say if there's any disruption or delay that the subcontractors to bear all of the risk, whether or not they caused it. We're now suggesting that if there's supplementing of materials or labor on a particular element for a subcontractor, that they can be supplemented and the cost as direct loss recovered directly. Whether or not they actually get mobilized is going to be more of a contract by contract basis. Well, my point really is that the existing contract mechanisms that are in place will be the first test to measure. If the current clauses, either be they amended or unamended, either at the time or now, or whatever agreements are saying, that will be the first point that parties ought to be looking towards. If the mechanism or if the contract or if the conditions deal adequately with this scenario, they of course will be. They answer the question. And of course, now it becomes important what that question is. So this becomes a real area now of what evidence is actually being created. And the only way to do that is to actually measure against what was the baseline intent, what was the intentions. If we're constructing cores, or if we're constructing multi-story concrete frames or into second fix, what type of resource, what type of time, we need to really understand what did we intend in the first place, what's the likely outcome, what's the likely changes, and start running those cash flow forecasts for each given project, each given activity, and see what the effects are towards the end. Very, very understanding point is, who are we interacting with? How many different interactions from different stakeholders? What threats are they actually coming back? All of this has a magnifying glass, but nothing has changed. This has always been in this case, and we've often dealt with cases like this. This is now a magnifying glass and those real good principles. So as much as parties, as much as teams on construction sites are being certainly coached and certainly being given toolbox talks and education surrounding the health aspects, we've also now got to look at the health of the contract and the health of the performance and the health of the actual financial points. So we're now, for long-term, our cash forecasts for sites, we're now actually looking for those to be done more regularly, even on a weekly basis. And now to start revising to say, can we actually understand that if beforehand our cash flow forecast as a business was maybe 1 or 2 months behind on our accruals, can we actually now start looking at them and do balance sheet tests very, very quickly on those points? And then start looking at the points of foreseeability. If we see risks, can we reach agreement on those? But a clear point here that we've moved on from the lockdown. We're now moving really closely and really far into the point that this is an environment where leaving it till the final account and expecting for it to be resolved then is not a good idea. It should be dealt with now. It has changed, and understanding that change. These are the most difficult areas to prove in any given respect, disruption, and especially with any concurrent delays, or where concurrent delays are actually going to be referenced. They are the most difficult areas to prove, and they are the most contentious areas to prove. So it is most likely to expect that these will be the areas that will be debated upon. Leaving it to a final account is probably not going to be the most sufficient way when we go forward. Moving on to where we currently stand, and why hasn't this all been resolved? And the simple point about it is that when we look at the Coronavirus Act of 2020, or any of the regulations, what we've seen, and with due respect and complete sympathy, this was a complete something that happened, nobody expected, of course, or it certainly moved at such a pace. The amount of updates that was provided in the guidance, for example, which we're now getting into very legally interesting arguments about the effect of the guidance against regulations. Construction itself seems to have bypassed the full effects of quite a lot of those points, and the ability of how the guidance, especially at the time, would actually support or not support. So those debates really become live ones very, very quickly. My suggestion is that we don't actually really seek to rely on a future outcome by assuming that every single provision will automatically support either a contractor or subcontractor or those parties downwards as well. Certainly those are the different instances as well. How we actually tender, of course, now on future projects has completely changed as well, of course, because we mentioned earlier on foreseeability. Foreseeability is one of the key ingredients. If it's foreseeable that perhaps parties are talking about second wave, or that there will be social distancing for quite an element of time, well, then all prices and all risk must be within the fact that it was foreseeable that these measures would be in place. So tendering periods, as though tendering periods could do with any more complication, because it really is one of the fall down areas of construction is the time and quality spent on tendering, which leads to all of the problems. We've often said that 80% or to 90% of all of the problems that ever happen actually occurred at the time of contract formation, or certainly during the tendering period. It's just the fact that the problems never manifested themselves until later on. But certainly with the foreseeability issues now in place, and of course this creates a huge problem for those who are estimating, because now they're estimating on something that really they have nothing to track against, nothing to back analyze against on performance. How does somebody know now what is the right figure? So we have that variance, and anything on, as I said before, low margins or long payment terms will really affect that cash flow, especially if there's disputed amounts. So the mechanism of how to resolve disputes, how to actually, but the key question is really for parties to really start understanding what currently is in their contract. What is it currently under contract in terms of insurances? It's very unlikely you're going to benefit from any unforeseeable events now with a pandemic. It's especially from an insurance point of view. So the question would be, how many parties that are listening this morning have actually talked to their insurance brokers recently about all of the different effects on their policies, and certainly on any interruption, or if they're lucky enough, one can imagine trying to get a business interruption loan at this stage as well, the premium. But how does it affect those different points running through as well? So the key questions really will be, is as much as possible, is that foreseeability. The difficulty as it actually sits in any different event. This is an industry, as we said beforehand, and I just repeat again, up until the 31st of March, 3,077. Most parties had been really concerned about Brexit before this. Now we face this effect of potential Brexit sitting alongside a pandemic, which is just, it's insurmountable to actually consider when combined the two effects themselves, because they already had that effect. Coupling that as well is that if parties are squeezing in terms of how their workflow is coming through, if they have any contingent liabilities or any liabilities sitting on their books that will flow through, including VAT, including any of those outgoings that must become realized next year. How does all that shape up? How does all that face together? And looking on a contracting market, potentially, and then of course with all of those liabilities coming in from behind. So the element of being able to look at the certainty of different contracts, the certainty of how we approach the delays, timing is now, it's certainly not later on. This will be one of those very good examples of where entering into disputes must be really considered. Is it worthwhile? Disputes can be an incredibly unpleasant environment and costly. To avoid disputes at this stage will be one of the key points of how that is actually avoided. So understanding now and what those agreements will look like to provide for the certainty of that as well. Okay, well, I'm going to bring that to an end, and if there's any questions, do feel free to ask. Okay, thanks very much.
Okay, thanks, Henry. That provided a fair bit of clarity there on something that isn't easy to provide clarity on. We've got a question here from one of our attendees who's currently pricing a scheme. The business intends to add a blanket clause stating that our tender makes no allowance for COVID-19 related events. Would the fact of foreseeability for COVID-19 override a blanket exclusion clarification, and therefore we should have deemed to have included the COVID-19 issues, both cost and programme impact for any future claim?
Yeah, okay, so that's pretty much it. So what the party has tried to do is to essentially say, we don't really care what's happening in the world. We're just going to go on our straight line, and we're going to try and rely upon a catch-all clause, effectively saying, if there's anything that all relates to COVID-19, basically we're not responsible for that, and we'll want time and money in that respect. And ultimately, as a principal point, there kind of is nothing wrong with that. The problem is the ambiguity or the certainty. What is a COVID-19 related event? Is like, how do you define that? So this is quite simply, how long is a piece of string? So the right way that one would tackle that would be to actually create a defined term and create out essentially what all of those listed items would be. And there's nothing wrong, because like, no, by saying what the party, stripping it down, what the party's actually done is they've actually really trying to insert a force majeure clause, realistically, if it doesn't exist. And to be effective, a force majeure clause would have, say, listed or unlisted items. So all the party and all from the questions come from, what they're trying to do is something that has always been done before, realistically. But to get it really clinical is that if you want to stay on your straight line, that what your expectation would be as a baseline, effectively, that we're going to imagine for 1 second here that nothing in the world has been affected by COVID-19. What would that look like? And that would be the sequence, that would be the cost, that would be everything surrounding that. Use that as a baseline, and then anything by a COVID-19 event will impact on that. So the couple of points does come into play here. Foreseeability, and the person asking the question is right to ask that. If it was foreseeable of this extent, well, it is. So how they would draft that would need to be really, really clear, really exact, because it could offend the point of view of a force majeure in any event. Because when you're forming the contract, if it's foreseeable, well, then that's going to be an issue. It should be taken into account. So the drafting would really, really need to be really clear. But essentially, that what the party is trying to do is they're trying to create that baseline, and they're trying to say, for that to be effective, they would nearly need to list out all of the different elements that could be affected by that. But there is, in a different way of tackling that, is something I agree with, like, no, is foreseeability. How does it actually relate back to, which again, we're back to principles of contract, which exist anyway. So where do we sit with, say, fluctuation clauses? Where do we sit with material prices? Have we taken the effect of we've contacted as many suppliers as possible, knowing that we've 6 months left on a given project? Are they going to raise their prices, for example? Or do we have those agreements in place? Or are we now going to basically suggest that any increase in those prices in a subsequent agreement with the employer, based on the current events, will actually be recoverable by the employer? But if we do nothing, then most likely it's going to sit with us. But in tendering in the future, COVID-19 is foreseeable. It's there, so nobody's going to be very, very impressed by an argument saying an unforeseeable event because we thought it'd gone away. It simply hasn't. But creating that baseline and changes away from that baseline is absolutely fine. The success, I would think, in the tendering on a risk base, it could lead to ambiguity. So we'll need quite careful drafting.
Okay. Someone else asks, we're currently negotiating a COVID program where the contract was tendered pre-COVID. What are some key things the contractor would need to demonstrate to justify their program extension?
Yeah, this is exactly it. This is exactly where it's all going to be the problems, is the proof of that. So if we're dealing with a program that was pre-COVID, for example, we're going to establish that as being the baseline and the common intention at the time of contract. So the first nature really now is to look at what the quality of that was. And we can deal with quality of evidence like a spectrum. On one hand, we might have a program which has 3 to 4 activity bars, just no link logic. It just doesn't even look right, and it's really scant on detail. Or we can deal with one that's heavily resourced. Each activity bar has the resources, the materials, everything, critical path, and looks exceptionally well. So the first thing is, what's the quality of the baseline program to measure against? Sitting towards then is then the quality of the activities that you would be taking post-COVID. What was the intention pre-COVID? How has it changed? And therefore, can we actually attach the liability of that change to another party who is the paying party? Is it their liability? And have we got enough on a legal basis to actually say, well, that is the actual responsibility? But even then, the change to that, the outcome or the loss or the change of the program, we must maintain the causation issue. And that is going to be one of the real key difficulties in parties proving their losses and proving the claims and proving time differences. Because if we're now looking at outputs now reducing 80, 70, down to 80, 70%, whatever they may be, well, then we might be able to physically see that there has been a change in production, but can we actually now prove that on a legal sense of causation? And can we now take that evidence that we've built up? This is the time to start preparing for this. It's too late at final account and do it retrospectively. It's an expensive process to do it retrospectively. And what is, like every single dispute that we've back analyzed, and when we look at disputes that were won or disputes that were lost, either in adjudication or any different legal proceedings, the quality of evidence and getting the right evidence. This is an industry awash with an abundance of information and data, but it's getting the right and the quality of that data that actually hits in and keys into, especially I'll mention again, is causation. That will be one of the proof of causation, will be one of the biggest issues.
Okay. Someone else is asking, has COVID-19 generally been accepted as force majeure under JCT contracts?
There's going to be difficulty surrounding, and certainly in terms of how I've been interacting is to seek agreement on the different points. Remember as well that even if it is, okay, so first of all, okay, we're going to be seeing, there's no doubt this will be treated judicially, but there is very little judicially there already with force majeure and JCT, very little. It's not a defined term. It doesn't hold any of those different points. So I've, in one respect, I have not been taken as a given. There are strong indications, of course, that there would be a lot of sympathy. I think that when you look at the guidance, which was updated 4 times in that principle, was to say that anybody who was to act very harshly, poor view should be taken. But this is guidance. So we're into a hierarchy of how acts of parliament have actually been brought in. If we go into that stage, it's guidance. Is it legally binding? So just because the guidance actually suggests, like now I've heard different arguments about changes in law, will it immediately kick in that it's an instruction, that it's changed after the base date? And I don't think, and generally the current conversations are, that's not particularly strong. There's probably more hope with something like NEC than JCT with that. But as to whether or not it's a force majeure, I can imagine that there would be sympathy on that point. But even if we do get to that point, and it is a force majeure, what we've actually got here is we have a force majeure event for perhaps a month and a half, 2 months, whatever the period of that time. That's what we've got. And if it is under JCT, we have relief from liquidated damages essentially for that time. The problem is bigger. It's much bigger than this, like not just from the force majeure argument itself, in terms of that element of everybody being in lockdown. It's the post, that's where the money, because it's, even if it is a force majeure event in JCT, there's no entitlement to loss and expense. It just simply isn't. So we still have to deal with the element of money no matter what, if it is a force majeure. And that's where the issues are going to start running as we come out of lockdown and we're now moving into the future. How do we deal with the changes in the areas of any of those points coming through? It goes further. And that is where the legal issue of causation post-lockdown, because like if we're talking about a month and a half, that is not injuriously going to affect every single company. It's the effects afterwards.
Okay. And then we've been asked, what about small domestic contracts, say up to $500,000, where there is an adequate contract, for example, Federation of Master Builders, or a handwritten agreement, or worse still, acceptance of a very vague contractor's estimate assessed on poor or inadequate documents, something that the writer frequently encounters. What then is the approach as to how COVID might have affected the contract and any potential contractor's claim?
Okay, so again, this is these are questions that if it wasn't COVID, it could be something else. Okay, and that's the key message. With the contract provisions, they are there. So in terms of, if we look again at the quality of what a decision would be in terms of an outcome of a dispute, the reason why parties go into a dispute is because there's not that certainty of the application of provisions. The more detailed those provisions are, and the more they deal, and they're really plain to deal with a particular situation, the more likely it is that it won't go into dispute, because it's very, very clear. Disputes happen over not being clear on these instances. So if we look at, if we have right to the very end, first of all, if we're dealing with domestic contracts, it might fall under Section 106 in the Construction Act, which means that the Act is actually excluded for residential. So that's one starting point, anyway, in relation to that. So, and then looking to the next point, it was verbal. That's another point. So how do we actually prove what the actual terms was? So before we even go into something really sophisticated as a document being produced, we're now dealing with that where we're struggling already, to say whether or not these provisions, or how does the guidance interact with the Coronavirus 2020 Act? All of these different points are guidance, not mandatory, not statutory changes. Suddenly then, we're now dealing with a verbal. But clearly, we're going to have more difficulties, because not only can we not establish what the provisions were, we're going to have the issues at what was agreed in the first instance. The key thing about it is, for any of those points, will be the same rules. It will be to ascertain what was it that the parties actually agreed to it. Can we, on the balance of probabilities, ascertain that that was an agreement, or what the common intention was? It's harder to prove, of course, if there's those expressed words. And then ultimately then say, how does the effect arrive at that? So first point is, what did the party then actually parties agree to? And then ultimately, was the event foreseeable? And if it was foreseeable, well, how does that actually now interact against the agreement the parties made? So I'm afraid to say with the verbal agreement, but the Construction Act certainly will, unless it's a specific contract that it includes for those points. But ultimately, that would face more of a problem.
Okay, and then we've got a final question here. Please ask Henry, were the provisions of contract deal with a change in law? How do you see this effect on a delay, disruption, or acceleration due to COVID-19?
Yeah, so this has been raised a number of different times. I think there's more chance with X2 one and NEC, the wording seems to support that a little bit more. I don't particularly, and I've seen quite numerous different points of commentary. The first question that would be raised, what is the change in the law? What is the change in the statutory position? So that's the first question, because if you can mobilize that, well, of course, certainly NEC will assist on that point. And then on JCT, you'd be looking at the base stage and then instruction on the statutory requirement. But the first question really has to be, what has the change been? And like no parties really, and there has been quite a lot written about this, like no from some really leading QCs on the effects of how the differences between the guidance, the act, essentially how construction industry, you know, where does that sit with all of that? So if somebody is going to suggest where, like, no, that this is a change in the law after the base date, the first question has to be, what was the change in the law or the change in the statutory requirement? Because the ranking, because if we go into the certain elements of the guidance, it's not particularly, first of all, is a mandatory and it's not particularly clear. So it's not my first point to run on that sense, although I do see that NEC does provide that more certainty and opportunity than JCT does.
Okay, that's great. That's the end of the questions, and there are some quite detailed questions there. So thank you for that, those very detailed answers. Thank you everyone for attending. Those of you that are going back to work, please stay safe. And those of you that are waiting return to work, hopefully that will be soon. And we will see you all. We've got another session later on tonight, and also Henry is online tomorrow, 5 o'clock, talking about COVID-19 versus adjudication. Those of you that haven't already booked a place, please drop me an email, seminars@silverllp.com, and I'll book you in. Henry, thank you very much for your time and expertise. We'll see everyone later. Have a good day.
Okay, thanks very much.